calling you and asking you and have you say, well, it's in the beneficiary declaration, and then you say, but you don't have that document. How would she know? How does she go about finding out that information?
Object to the form.
It's not a funny matter. Do you know what I'm saying? I mean, she has real concern about the information there which says, Freddie Mac owns your loan. Senlar is the servicer. Senlar is the creditor to whom the debt is owed. And she doesn't really know, as you sit here, you don't know either. What is the difference between an actual holder versus a holder? And so the question I'm posing to you is not to be comical.
I'm not trying to be comical.
And the question is one of fact. It's not a legal conclusion. It's not for you to analyze. It's simply, if I want to know who holds my note amongst all these entities that are named in the notice of default, how do I do it?
Object to the form.
I don't know how to answer your question.
Do you don't know how to answer, or you don't have an answer at all?
Both.
So is it fair to say that within your company,
Record reflect, it is now 10:34 a.m. and we're back on the record.
Okay, Ms. McElligott, I'm going to ask you to refer back to Exhibit 4.
I don't have an Exhibit 4.
I'm sorry, whichever one you have here. 3, I'm sorry, 3. And stay on the foreclosure loss myth form, okay? And I'm asking you, in looking at that particular page, which is dated for August 14, 2012, does that document allow you to confirm that Senlar was the beneficiary at that time?
Object to the form.
They are signing as the beneficiary.
And that's your conclusion, that they are in fact the beneficiary at that time?
They signed it as the undersigned beneficiary or authorized agent for the beneficiary hereby.
All right, so let's go with that. The check mark that is located there under 1, is that what you're reading to me?
No, I was reading above that.
Okay, that's fine. By looking at this document though, do we know whether it is the beneficiary or the agent for the beneficiary that is Senlar?
No.
Just so I can be clear, when you received the referral in this case, in the Lucero matter, did you receive it from Senlar?
As I recall, yes.
Okay. And in looking at Exhibit 3, would it have been sometime prior to August 2012 that you received the referral?
Not necessarily.
So explain that to me. This is the notice of default that was sent out to my client sometime in August of 2012.
Sorry.
My question then, would you have received the referral prior to this time?
To this document, or the notice of default, or the loss net form?
Well, let's talk about the time that you received the referral. Okay? Can we assume that it was before August of 2012?
Object to the form.
No.
How did you come about the information that is contained in the notice of default?
From the referral.
Would you have received it before you composed or prepared the notice of default?
Yes.
So that, and the dates that you're looking at in Exhibit 3 are dates in August of 2012?
Correct.
So then again, my question is it safe to assume that you received the referral sometime, either during that month or earlier than August of 2012?
Yes.
Right? And when you receive the referral, is the lost MIT declaration or form there indicates to you that they were the beneficiary? Senlar, they being Senlar.
Object to the form.
Strike that. Let me ask you a better question. At what point in time were you able to confirm that Senlar was the beneficiary for purpose of foreclosing on this Lucero?
I don't know.
Did it help you at all in looking at Exhibit 3?
No.
Okay. How about the lost MIT form?
This doesn't give me a specific. I'm not quite sure. I don't understand your question.
When you received the referral, did you need the information of who the beneficiary is in order to commence the foreclosure?
Yes.
Where did that information come from in this case?
The original information would have been on the referral.
And, but yet, when looking at the lost MIT form, you can't say whether it is Senlar.
What?
That is the beneficiary.
They signed as the beneficiary's agent. Authorized agent.
Or,
Correct?
correct?
Correct.
In your practice, when does Northwest Trustee become the trustee?
When we receive an appointment and send it to record. We record.
You've been handed Exhibit 4. Can you identify it?
The appointment of successor trustee.
Relating to the Lucero case?
Yes.
Do you know who prepared Exhibit 4?
No.
Is your name appearing on the header there gives you an indication?
That it was done on my team, yes.
Okay. So the language that's contained in Exhibit 4, is that also a template?
Yes.
And this template is found in, within your system, which is being used to foreclose non-judicially in Washington, correct?
Object.
Correct.
I want you to look at the text or the language right below appointment of successor trustee here, Ms. McElligott. And where the paragraph starts with the present beneficiary under said deed of trust appoints Northwest trustee. Do you see that?
State that again?
Read the second paragraph down from the heading of appointment of successor trustee. Do you okay while I'm reading off to you? You see the sentence that start with the present beneficiary? Yes. Okay. Who is the present beneficiary in this exhibit?
There's not a statement to that effect.
There is not?
The present beneficiary signed by Sunlar.
Okay. And what is the date?
The date of the signature is 10/3/12.
Does that lead you to believe that that document was signed on that date?
It does.
And who signed this appointment of successor trustee?
Michael Blair
In what capacity did he
as
sign?
vice president.
Do you know Mr. Blair personally?
No, I do not.
Did you look to the notaries at the station there? Do you see that?
Yes.
Do you know who Nancy K. Morris is?
No, I do not.
You had, in the past, acted as a notary public. Is that true?
Correct.
All right. So is it your understanding that in a document like this, as a notary public, the notary has to verify not only that of Mr. Blair's identification, but also his official capacity? Is that right?
Yes.
Okay. And do you agree that Exhibit 4 is lacking of that verification?
No, I do not agree.
What do you see the blank spaces there?
I do.
Okay, if you were the notary public, would you have filled in the blank spaces?
Yes,
Okay. And you agree that there are blank in this exhibit?
yes.
And in terms of the date of the exhibit being October 3rd, 2012, that doesn't tell you when you received it back from Senlar, does it?
No, it does not.
And how did you transmit Exhibit 4 to Senlar? And when I say you, I'm referring to your company, Northwest.
I have to assume we uploaded it through LPS.
Would you have uploaded the appointment and the assignment of deed of trust simultaneously?
I don't know.
Is it a practice to upload them simultaneously?
Not particularly. It's a case-by-case basis.
So explain the logical sequence or the timing when you upload these two particular documents, the assignment of deed of trust and the appointment of successor trustee.
Depends on if an assignment is needed, required, necessary, or if we're even asked to draft it at all.
In this case, can you tell me why the appointment was necessary?
To appoint a successor trustee.
Because you were not originally named, correct?
Correct.
So it was necessary.
Yes.
All right. So in the event or under these circumstances, when you determined that the appointment was necessary, what logical steps did you take?
To draft the appointment and upload it to the servicer, to the website, the LPS.
And what would serve as the basis for the appointment, if you understand my question?
I don't understand your question.
Who can appoint your company to be successor trustee?
The beneficiary.
Okay. And in this case, when you uploaded this, or your team uploaded this Exhibit 4, who was the beneficiary?
Object to the front.
I have no way of knowing that from what's presented in front of me.
Okay. Who did you send Exhibit 4 to?
We uploaded it through LPS to Sunlar.
And it did come back from Senlar, being signed by Senlar, is it not?
Correct.
Right. So, in looking at Exhibit 4, do you conclude that Senlar was the beneficiary on the date that they executed Exhibit 4?
Yes.
You've been handed Exhibit 5, Ms. McElligott. Can you take a look and tell me whether you're familiar or recognize that exhibit?
Yes.
What is it?
An assignment of deed of trust.
What is your understanding? First of all, does it appear that Exhibit 5 was prepared by Northwest Trustee?
It does.
When I say that, the preparation would exclude the signatures and the dates, correct?
Correct.
And what is the purpose of the assignment of deed of trust, Exhibit 5 here as you see it?
Object to the front.
To put a public record.
To do what?
To put the assignment of public record.
Why?
I'd like to see it that way.
What would be the purpose of Northwest Trustee recording the assignment of deed of trust in the public record?
Restate your,
When you look at Exhibit 5, do you agree that it was recorded
yes,
in King County Public Records?
yes.
My question to you is why?
To put the current beneficiary of public record
Who was the previous beneficiary?
on the deed of trust, it was MERS.
Who was the current beneficiary?
I don't understand your question.
The original beneficiary was MERS, you testified.
Yes.
The assignment transferred from MERS to who?
Oh, Sunlar, FSB.
And who decided
strike that. So by virtue of your testimony, the assignment of deed of trust, Exhibit 5 here, the purpose of recording it is to show that the interest had gone from MERS to Senlar, correct?
Object to the form.
Yeah.
And is it true that Exhibit 5 serves as the basis for your authority as successor trustee?
Object to the form.
No.
What is the basis for Northwest trustee authority to conduct Lucero's foreclosure?
Repeat the question.
What is the basis of your company's legal authority to commence the foreclosure on my client's home?
Object to the form.
The referral that we received based on the deed of trust
And
and the
then,
default of the mortgage.
and that is based on the referrer being signed by Senlar.
Correct.
And your testimony now on Exhibit 4, if you want to refer back to Exhibit 4, do you rely on Exhibit 4 as the legal authority for your company to foreclose on my client's home?
It's appointing us the trustee and to act as the trustee to process the foreclosure.
Is that to you the same as having the legal authority to do so?
Object to the form.
Let me put it to you this way. Let me put it to you this way. If there was no appointment of successor trustee, could Northwest trustee commence foreclosure on my client's home?
No.
And when you look at Exhibit 5, does it not logically transfer whatever interest MERS had in the original deed of trust to Senlar?
Object to the form.
No, not the assignment.
What does it do?
Object to the form.
As we already discussed, it puts Senlar in public record as being the beneficiary.
And you don't need that. You don't have to rely on that for your
The law
authority.
does not require that an assignment be recorded.
Then why? That's what I'm trying to get at, is that if you didn't need it, why did you record it?
Most servicers want it a public record with an assignment.
What is the rationale for that?
Object to the form.
Not for me to answer.
Do you know at all?
I have no opinion.
Okay, so in preparing and recording Exhibit 5, you simply follow instructions by Senlar as one of those servicers? Is that correct?
Correct.
Okay, and you have no idea why you did that independently?
Object to the form.
Is that
We are asked to record an assignment. We record an assignment.
by Senlar?
Correct.
And in your mind, Exhibit 5 doesn't relate to Exhibit 4 in any way.
Object to the form.
You need to be more specific.
Does Exhibit 5 serve as a foundation for your authority as successor trustee?
No.
Why not?
Object to the
Why?
form.
How did you become successor trustee?
By recording my appointment signed by the beneficiary.
And how did Senlar become beneficiary?
By being the holder of the note
How did you know that?
with the beneficiary declaration.
And the beneficiary declaration came from where?
We don't have that in front of us.
Okay, but can you presume where it came from? Because I'm going to show it to you, but in your practice, where does the beneficiary declaration usually come from?
The holder of the note.
How do you know?
Because I have a declaration stating such.
I see. So if you get a beneficiary declaration, that is the evidence to you that the person or the entity executing it is the holder of the note. Is that a fair summary of your testimony? Okay. So let me ask you again. Is Exhibit 5 completely unnecessary for your work as Northwest trustee in foreclosing on my client's home?
Object to the form.
I want an answer.
Is it completely unnecessary? Yes.
Then why in the world did you record it?
Object to the form.
And I believe I already answered that.
which is,
Most servicers with lenders require that an assignment be of record.
and in this case, it's Senlar.
Yes.
Object to the form.
I'm going to ask you to look at Exhibit 4 and 5 and look at the recording dates of these documents for me, if you don't mind. Can you tell me when they were recorded, the date of it,
December 6, 2012.
and what time?
$14.15.
Okay. And in what particular order?
The assignment is recorded first.
Why?
Object to the form.
Best practices.
Why?
Object to the form.
Best practices.
Why is it best? Why is it better than not recording them in that particular chronological order?
That's the order in which we normally record best practices.
That the assignment has to come before the appointment. Isn't that true?
Yes.
Even though the date says otherwise.
Object to the form.
Is that correct?
Yes, it is correct.
Okay. And that is, as your testimony, best practice utilized by your company in this case, as well as in other cases.
Correct.
Is that practice still in place today?
Yes.
Asking you to look at Exhibit 6 now, Ms. McElligott, and do you recognize Exhibit 6?
As a document, yes.
Okay. What is it?
An appointment as successor trustee.
And does it appear that your team prepared that?
It does.
And what is the date of this appointment of successor trustee?
December 17th of 08.
And do you recognize the person who signed
Yes.
that? Do you recognize the name of the person who notarized?
Yes.
And these two people work for your company, is that correct?
Yes.
You're now looking at Exhibit 7. Ms. McElligott, do you recognize 7?
Yes.
What is 7?
An assignment of deed trust.
Does it relate to the appointment that you just testified in the previous exhibit? 6.
Yes.
Okay. What is the date of Exhibit 7?
December 19th of 08.
So in this case, again, does this set of documents, 6 and 7, reflect the practice, the best practice you just testified to?
Object to the form.
The assignment recorded before the appointment.
Correct, but they're dated in reverse order,
Yes.
meaning they were signed in the reverse order. Is that correct?
But recorded assignment first, appointment second.
And that is the best practice that Northwest engages in, regardless of when the documents were signed.
Yes.
And your testimony is that that practice is still being utilized in present day.
That is.
When you send the assignment and the appointment in the Lucero matter to Senlar for signing,
was there a request made by Northwest for them to be signed in the proper order, which is consistent with the order that you report them,
Object to the front.
according to your best practice?
Object to the front.
No.
And do you know why that is not being requested or informed to Semlar?
No.
Because it doesn't matter to Northwest at all when the documents were signed,
Object to the front.
correct?
Correct.
So long as they're recorded in the right order, then you guys are good to go.
Object to the front. Object to the front.
Sure.
You've been handed Exhibit 8. Do you recognize Exhibit 8?
Yes.
What is it?
Beneficiary declaration.
In the Lucero
Lucero
matter?
case.
Okay. Does Exhibit 8 look to you to be a form generated by Northwest Trustee and sent over to Semlar?
Object to the front.
It does appear to be ours, yes.
It does? Okay. And the identification, and when I said form, can you tell me when you sent it to Semlar, does it appear to be exactly as Exhibit 8 shows, minus the date, the signature? Do you understand what I'm saying? The form has already been formatted and sent over to Semlar simply to collect a signature on it, is that correct?
Object to the front.
Yes.
Okay. So for example, if you look at the header, beneficiary declaration, and the words note holder in parentheses, do you see that?
Yes.
That is the language that is being, that was used by Northwest Trustee in the template.
Correct.
Semlar did not put it there.
Not that I'm aware of.
Okay. And you also inputted the loan number, is that correct?
That would be my assumption. I can't say for sure.
And the property address will be populated into this form.
Yes.
And the language, the underside, under penalty of perjury declares as follows. That is Northwest language.
Correct.
And then the identification, Semlar FSB is the holder of the promissory note or other obligation evidencing the above reference loan. That is Northwest language, is it not?
Yes.
Semlar did not give you that verbiage to put in there.
Correct. Well, actually, I don't know that for certain because there are some documents where they do give us the format, and I can't say for sure that this isn't a format that they approved and required. So I can't say that for sure.
But it does look familiar to you as a form that is used by Northwest, correct?
Correct.
All right. And so who decides to put Semlar FSB in there as being identified as the holder of the promissory note?
Our instructions with the referral would be to list them as
As
our
the,
FSB,
okay, as the holder.
as the foreclosed in the name of, and the holder of the note, yes.
Okay. So the instruction is not only for Semlar to be foreclosed in the name of, but also as the holder. And you have no evidence other than this form that you sent over for them to sign and send back.
Object to the front.
Evidence of what?
That they are a holder. For example, the location where they hold the note.
Correct.
Right? You don't have any independent evidence whatsoever.
Object to the front.
Am I correct?
Correct.
What is the date of Exhibit 8?
October 5th, 2012.
And in looking at Exhibit 8, you would not know when it was returned to you with the signature.
No, I would not.
Who signed Exhibit 8?
Jennifer Dobrin?
Do you know who she is?
No.
If you don't mind, I'd like for you to go back to Exhibit 5 and keep Exhibit 8 next to you, next to Exhibit 5. Have you done that? Okay. By looking at both of these exhibits, do you recognize Ms. Dobrin to be the same signatory on the assignment of deed of trust, as
Yes.
well as the beneficiary declaration?
Yes.
Does it confirm for you that she is in fact, or was at that time, an employee of Senlar?
Object to the form.
Yes.
You didn't send Exhibit 5 to MERS to be signed?
No.
You are now looking at Exhibit 9. Do you recognize Exhibit 9?
Yes.
What is it?
It's a beneficiary declaration.
In the Lucero case.
Yes.
And what is Exhibit 9? When is it dated?
October 16th, 2012.
Does that signify to you that that was the date that the exhibit was signed?
Yes.
When you look at Exhibit 9 and Exhibit 8 side by side, can you confirm that both of them are the product of the template being used by NWTS Trustee?
I assume, yes.
Do these two exhibits differ in any respect other than the date and the signature appearing in the signature block?
And the whiting out a proportion of the loan number.
Right, correct. Any other respect that they're different?
No, not really, no.
Do you know why there are two beneficiary declarations provided in the Lucero case?
I have no idea.
Does that happen in other cases?
Periodically, yes.
And do you know why that is?
No idea.
When you sent over these forms to the servicer, in this case Sandlar, how many copies do you need? How many, I'm sorry, strike that. How many declarations do you need?
Just one.
And in looking at Exhibit 8 and 9, since you don't know who Ms. Dobrin is, you have no idea whether she herself signed these documents or not, do you?
No, I do not.
Now, I will represent to you that both 8 and 9 was submitted in the mediation and the lawsuit in this case. Is it the practice of your company to submit different versions of beneficiary declarations for purpose of mediation and litigation?
Object to the form.
And I have no way to answer that, because I'm not involved in the mediation or the lawsuit. Document provided.
You're looking at Exhibit 10. Does it look familiar to you?
As a beneficiary declaration.
Is it similar to 8 and 9 that you were looking at in terms of the template language?
Yes.
And what date is Exhibit 10?
11/9/2013.
We're now looking at 11. And I'm asking you to compare 10 and 11. Are they similar in the template, language, and format that you have been testifying?
Yes.
Okay. And what is the date of Exhibit 11?
June 7th, 2013.
And are the signatories different in these two beneficiary declarations,
Yes.
10 and 11? And I know that you testify you're not involved in mediation, but if we were to go to your file, the foreclosure file, would Exhibit 9 and 10 be included in that system?
Object to the front.
And I'm confusing you. Let's just go with the set that you're holding right there. 10 and 11.
Without being in front of the computer, I can't testify that they're there.
But there's a good chance, right?
Correct.
So then again, if I were to ask you to put down those 10 and 11 and look at 8 and 9, would you say that if I were to review your Lucero foreclosure file, I would find 8 and 9 in your file?
Yes.
You're looking at Exhibit 12, Ms. McElligott. Does Exhibit 12 look familiar to you?
Yes.
What is Exhibit 12?
Notice of default.
Issued to a borrower by the name of Donna Costello.
Yes.
Okay. What is the date of Exhibit 12?
June 25th, 2012.
I've asked you questions relating to the Lucero notice of default, but I'm going to ask you to confirm for me the same thing. When you look at the, now would be the third page of Exhibit 12, do you see the, under paragraph D, itemized account of the arrears, do you see that?
Yes.
Would it be also true in this case with Costello that you had, that Northwest Trustee obtained the delinquent monthly payments information from the servicer?
From Wells Fargo, yes.
I'm sorry, what did you say?
Wells Fargo?
And as well as the late fees or late charges.
Correct.
And the lender's fees and costs there, do you see that?
Yes.
Would that relate to Northwest Trustee Services in this case?
No.
I'm sorry, was I asking you about lender's fees and costs? I apologize. So the lender's fees and costs the number was provided to you by Wells Fargo.
Correct.
Okay. And then the trustee fees right below it, $542.50.
Correct.
That will reflect the fees charged by your company
Yes.
for the issuance, for work up to the issuance of the notice of default.
Correct.
All right. So I understand from talking to Mr. Stenman on Friday that the trustee fees is prorated depending on how far you have gotten in the process, correct?
Correct.
Okay, so the number of $542.50 here, again, is the fee that your company charged in this case up to that point of the issuance of the notice of default.
Yes.
And the designation as trustee fees is a part of that template you testified about.
Yes.
Let's go down to paragraph K of Exhibit 12, where the contact information for note owner and loan servicer is being provided. Do you agree?
Yes.
Who's the owner of the note in Costello?
Freddie Mac.
Okay. And I know it's an assumption, but would it also hold true that the information as to Freddie being the owner came from the servicer, Wells Fargo?
Yes.
And who is the loan servicer according to Exhibit 12?
Wells Fargo Bank NA.
And do you agree with me that on the second page, the beneficiary is not identified?
Correct.
So you go to the second page of Exhibit 12 under paragraph C, similar to the Lucero case. Who declared Costello to be in default in this case?
The beneficiary.
And who is the beneficiary?
At that particular, I'm not. This is all you've given me. I have to make
Right.
assumptions that it's Wells Fargo Bank.
Okay. I'm asking you to refer to the document. That's all I'm asking you to do. Is it your assumption that the beneficiary is Wells Fargo?
Bank NA.
Okay. And how do you base, what facts do you base that assumption on?
The document.
Which document?
You just told me to base it on the document that I have in front of me. So
Okay.
that's all I have to go by.
I understand. But we just talked about the fact that the beneficiary is not identified by name. Correct?
Correct.
And you said, I assume that it's Wells Fargo. Do you recall that testimony?
Yes.
So I'm asking you what factual basis on this document that led you to assume that it's Wells Fargo as the beneficiary?
The document itself. You're asking me to look at a document and try to tell you who I might think the beneficiary is. That's my answer.
Right. Where in the document, in this notice of default, do you conclude?
That we are the duly authorized agent on behalf of Wells Fargo Bank.
What else?
They also signed this is a loss-mit declaration form as well, stating that they are the beneficiary's authorized agent.
Okay. So those are the indicators to you that the beneficiary, by virtue of deductive reasoning, is Wells Fargo Bank, NA.
Based on what you've given me only.
Based on the document itself, right? I'm not giving you anything else other than
Right.
the notice of default and the loss mit which is attached to it, correct?
Yes.
All right. I'm referring you to the third page of Exhibit 12 under paragraph L1, I'm sorry, L2. Can you read that sentence on L2?
Object to the farm.
You want me to read the entire paragraph?
Just one sentence.
Notice pursuant to the Fair Debt Collection Practices Act.
I'm sorry, just the one sentence under 2. You see the...
Oh, the creditor to whom the debt is owed is Wells Fargo Bank NA.
Okay. Is that the same as the beneficiary?
Object to the farm.
We don't often use the word creditor, except for the fact that it's in this format.
Which is the notice of default format.
Yes.
So for many, and I will be showing you a number of them, for the notices of default that are issued by Northwest Trustee, the creditor to whom the debt is owed is referred in many of them. Is that correct?
Yes, it's standard.
Okay, but your testimony is that outside of this context, you don't use creditor to whom the debt is owed.
We don't, yes.
And I guess my last question to you, I don't know if I got the answer from you, is the creditor to whom the debt is owed Wells Fargo?
Per this document, yes.
Okay. And what is the relation then of Freddie Mac when it is being identified by this document as the owner of the note?
Object to the form.
I don't understand your question.
Okay. Referring you back to the same document, this is the notice that your company sends out to borrowers, correct?
Yes.
Okay, so I'm referring you back to paragraph K. We've talked about the fact that, you know, the borrower here learns from this notice of default that the owner of the note is Freddie Mac. Can you look at K for me? Is that what it says?
Yes.
All right. So we're saying, you're telling me Wells Fargo NA is the beneficiary. Do you remember that testimony?
No,
Wells Fargo is not the beneficiary?
that's not, I'm just saying I don't remember specifically testifying to that, but go ahead.
Okay, so let me ask you that question. By looking at Exhibit 12, who is the beneficiary?
Wells Fargo Bank is what we're assuming based on this document that you provided me.
And who is the creditor to whom the debt is owed?
According to the document, it is Wells Fargo Bank NA.
All right. So what is the relationship of Freddie Mac as the note owner according to this exhibit?
Object to the form.
If there is a relationship that you know of.
I don't think this form defines a relationship.
What says that Freddie Mac is the owner of the note? Does it not?
Then they are the owner of the note according to the document.
All right. So can you reconcile between them being the owner of the note with Wells Fargo being the creditor to whom the debt is owed?
How would you have me reconcile it?
I'm just asking if you could.
Define reconcile.
Making it to be consistent,
Object.
that both can be true,
Object to the form.
are both capable of being true.
Object to the form.
I have no idea what you're asking me.
Okay, let me break it down for you. Exhibit 12 notifies the borrower that the owner of the loan is Freddie Mac. Do you agree? The owner of the note, I said.
Yeah, I don't
correctly.
agree that it's the owner of the loan. I agree that it's the owner of the note.
Okay. So if Freddie Mac is the owner of the note, who is the creditor to whom the debt is owed?
Object to the form.
According to the document in front of me, Wells Fargo.
Okay. So given those two things, one, Freddie owns the note, and Wells Fargo is the creditor to whom the debt is owed. I'm asking you, if in your mind, those two things can both be true.
Object to the form.
I don't have an answer for you.
Okay, that's fair enough. Can you even guess?
I'm
Object.
not going to guess.
And why wouldn't you have any opinion about those representations when they were in fact made by your company?
Object to the form.
I don't have to have an opinion.
What does that mean?
You're asking me if I have one, I'm telling you I don't.
Okay, so you have no opinions whatsoever. Your job is to obtain the information from the servicer, do exactly what they tell you to, and no more. Is that what you're
Object to
telling me?
Object to the form.
That's not what I said.
What is it that you're telling me
That I don't have an opinion.
regarding the information being conveyed to the borrowers in these notices of default?
Object to the form.
Right? You have no opinions
I have
whatsoever.
no opinion.
So your team participates in the creation and the transmission of these notices of default. and you have no opinion whatsoever. Is that
That is my answer.
right? I finally come with that answer. You're looking at 13. Ms. McElligott. Does 13 look familiar to you?
Notice of default that we generate, yes.
And the borrowers in this case are Frank and Sherry Lynn Schnars. Do you agree?
Yes.
And what is the date of this?
April 16th, 2013.
I'm going to ask you the same questions I asked you before, which is under paragraph D of the 3rd page of this particular exhibit. Northwest charged a trustee fees in this case, or requested a trustee fees in this case, correct?
Yes.
$612.50?
Yes.
And again, that is the reflection of the services rendered by Northwest up to the point of the notice of default being issued.
Yes.
And under paragraph K, where Northwest provides the owner with contact information for note owner and loan servicer, who's the owner of the note?
Freddie Mac.
Who's the loan servicer?
Bank of America.
And who was Northwest trustee acting as the duly authorized agent according to this exhibit?
Bank of America.
And who is the creditor to whom the debt is owed as specified by Northwest trustee?
Bank of America, NA.
And on the 3rd page of the exhibit, paragraph C, where the borrower is being notified as to who declares them to be in default, what does it say?
The beneficiary declares you in default.
Okay. Can you look through the exhibit and tell me whether the beneficiary is identified by name here in the notice of default?
No.
And then I want you to go to the last page of the exhibit, which is the foreclosure loss MIT declaration. Can you go there for me?
There.
And can you tell by looking at that last page who executed the foreclosure loss MIT declaration?
The person or the entity?
The person. If you can decide her name.
It says Marla Perez produced it.
Okay. And she was producing it on behalf of Bank of America?
She's signed underneath Bank of America, NA. Yes.
All right. So that was, and even though this page doesn't have your trustee sales number, it wouldn't have the trustee sales number at that point in time, would it?
This is their generated document.
Ah, okay, that's the difference. All right. And this is your evidence that, is this evidence that Bank of America is the beneficiary?
They signed as the beneficiary's authorized agent.
And you don't know which one they were signing it under?
Correct.
You're looking
Are you
at,
going to give me a copy?
you are looking at exhibit 14 now, Ms. McElligott. Does it look familiar to you? This is another notice of default issued by Northwest trustee, isn't it?
Yes.
to the borrower by the name of Ann Anderson.
Yes,
What's the date?
June 13th, 2012.
I think it says 13.
I thought that's what I said.
Is it 12 or 13?
I heard 12.
Okay.
For what's worth.
June 13th, 2012. 2013, there you go.
Okay. Next to that date, Ms. McElligott, it now says Nation Star Mortgage LLC by Northwest Trustee Services Inc. Trustee. Do you see that?
I do.
Can you explain why it says trustee this time instead of its duly authorized agent?
I can guess
Go ahead.
that we probably are the trustee.
At the time that you issued this notice of default.
Yes.
Okay. So let's go back to page 2. Itemized account of the arrears, paragraph D. Do you see that?
Yes.
Under the trustee, under itemized account of the arrears, the trustee fees is specified at $300.
Yes.
Do you see that? So if Northwest was at this time acting as trustee, that would be the fee charged for doing trustee's work. Correct?
Correct.
Okay. By looking at this exhibit though, however, would you be able to tell what specific services rendered by Northwest at that time? June 13, 2013.
I'm not sure I understand your question.
Remember when we were talking about the difference between Northwest Trustee acting as the duly authorized agent of the servicer? And in doing so, Northwest Trustee would receive a prorated fee for work relating to the issuance of the notice of default, right?
Yes.
And in this situation, you surmise or you guessed that by the time this notice of default was issued, Northwest had already been a trustee. Is that
That's what I surmised.
okay? And so I'm asking you that here, when the trustee fees is specified at $300, as we were looking at the other fees at $500 range, you wouldn't know what specific services provided by Northwest as trustee in this case, would you?
Object to the form.
I'm not quite sure I still understand what you're getting at as a question.
Okay. My understanding is, or let me just ask you, how does your company get paid by the servicer for the entire spectrum of the foreclosure process?
We either bill them at the very end of the foreclosure, whatever ends up happening, or every once in a while there's an interim invoice beforehand.
But do you bill them according to the actual work or services that you render?
As opposed to
A flat fee for,
billing them for fees I didn't incur? I don't quite understand your question.
as opposed to getting a flat fee no matter what you did or didn't do?
No, it's a flat fee based on a scale of what we did. So this is the flat fee for a notice of default for that particular servicer.
Okay. And, okay, so then the explanation then is $300 because it's a different servicer as opposed to the ones we talked about earlier.
It's a different fee schedule.
Nation Star as opposed to Wells Fargo. And can you tell me why, if in this case, when you go to paragraph K, it says the owner of the note is Freddie Mac. Do you see that?
Mm-hmm. Yes.
All right. Does your company get paid by Freddie Mac at all for doing foreclosures?
Not that I'm aware of.
And your fees would be, your fees as performing services, including pre-foreclosure or pre-appointment of successor trustee, is typically paid by the servicer, is that correct?
Object to the form.
Depends on the outcome of the foreclosure.
Right, but who pays the fee usually?
Depends on the outcome of the foreclosure.
Okay, so let's say it didn't go to sale. Who then pays the servicer?
It would
Who
still
then pays
depend
the
on what took
trustee?
place in regards to the foreclosure process.
But is the person who pays Northwest the same as the person who refers the foreclosure?
Not always, no.
Okay. So explain to me when it's not the referring source that pays you the fee. Who would be the likely individual or entity that pays you the
The
fee?
borrower would pay directly.
Really? When? When does that
When they
happen?
reinstate or pay off the loan,
Okay.
or when they get a loan modification, they end up paying the fees and costs.
Directly to Northwest?
Not necessarily directly, but
That's-
they are the ones who pay it.
Okay, so that's what I'm trying to track with you. The checks that you get as the trustee for services you render, according to that testimony, does it come from the borrower directly?
In which case?
In the scenario you just testified to,
Object to the form.
Okay.
when the borrower,
When the borrower
Reinstates.
reinstates or pay off their loan, most of the time, the invoice will go to the lender. You're absolutely, servicer, you're absolutely correct. There's periodic clients who insist that it be separated.
so under that scenario, the borrower would write you a separate check, correctly? Okay, is that your testimony?
That is,
All right, and then it would cover whatever services you provided up to that point.
yes.
Under paragraph L2, who is the creditor that this borrower owes the debt?
Nation Star Mortgage LLC.
Now, referring you back to second page of the exhibit, under paragraph C, who declared her to be in default?
The beneficiary.
And who is the beneficiary?
Nation Star Mortgage LLC.
I will ask you to take a look at the last page of this exhibit. And have you confirm for me, and that is the foreclosure loss mitigation form?
Yes,
Does it look like your form or somebody else's form?
somebody else's form.
Okay. And did Northwest rely on this loss mit form to conclude that Nation Star Mortgage LLC is the beneficiary
Object to the
or
form.
the beneficiary's agent?
Object to the form.
This document actually states their loss mitigation efforts as the beneficiary and or the beneficiary's authorized agent.
You're talking about the checkbox there, number 3?
Well, the whole document itself has to do with their loss mitigation.
Okay. But what do they represent themselves to be?
The beneficiary, the beneficiary's authorized agent.
Okay, so it's or, right? They're either the beneficiary or the beneficiary's authorized agent.
That's what this document says.
And in looking at the document, you as Northwest trustee arrived at the conclusion that they are in fact the beneficiary though.
Object to the form.
Or the beneficiary's authorized agent.
Okay. You're looking at exhibit 15. Does it look familiar to you?
Yes.
And exhibit 15 is another notice of default issued by Northwest trustee, correct?
Yes.
To a borrower by the name of Steve F. Morberg.
Yes.
And in this particular notice of default, what is the date?
July 20th of 2011.
And Northwest trustee issued the notice of default as the duly authorized agent for Bank of America. Do you agree?
Yes.
Okay. And who is Bank of America according to this exhibit?
Object to the form.
There is no statement as to who they are.
You didn't see
Except
the...
the creditor.
Okay. So there is the creditor to whom the debt is owed. Is that correct?
according to the document.
Yeah, as well as the loan servicer for this loan with Mr. Moore.
Yes.
And again, just to, just for the sake of consistency, I want to refer you back to paragraph C, where Northwest Trustees informs Mr. Morbert of the entity that has declared him to be in default. Do you see that?
Yes,
There's no name there, just that beneficiary declares you in default.
correct.
You're looking at Exhibit 16. Does it look familiar to you?
Yes,
Another notice of default issued by Northwest
correct.
on the Collins, Robert and Andrea, is that correct?
Yeah.
And can you tell me also in this exhibit, what is the date?
December 3rd, 2012.
And the notice of default was issued by Northwest in its capacity as the duly authorized agent for Wells Fargo Bank.
Yes,
Do you agree that this exhibit also represents that the loan servicer for in this case, is also Wells Fargo,
yes,
as well as Wells Fargo being the creditor to whom the debt is owed?
yes.
Is it possible that we could just stipulate that the documents say what they say?
No. You can stipulate. I just want to go through my questions. I'm almost done. Okay. And who is the owner of the note here, Ms. McElligott?
Federal Home Loan Mortgage Corporation.
In your capacity as the team manager or team supervisor for Freddie Mac's portfolio loans, how many notices of default would you say your team prepares in a week,
I have no idea.
in a month?
I have no way of giving you that number.
You're not keeping track of the volume of your work at all?
I don't keep track of the volume of the notices of default that goes out, no.
Okay. Is there any way that that information can be ascertained?
I'm assuming yes.
But as you sit here today, you have no inkling whatsoever how many
Do
you've
not.
done. In a particular year, like year to date for 2014, which you
No idea.
2013,
No idea.
2012.
None.
Okay. I want to refer you to the loss MIT form here as attached to Exhibit 16. Where the servicer in this case, strike that. Is it typical that the loss mitigation form or declaration, is it typical that it comes from the loan servicer?
The form,
What you see here, does it come
Object to
from
the
the
form.
servicer?
it is typical that the form comes from the loan servicer, yes.
So as a point of clarification, it can be a form generated by your company, as in earlier cases when we were looking at the Lucero's case.
Object
You want to go back to that exhibit?
I do. We did not generate this form.
So let me ask you the foundation question. Does Northwest have a template for beneficiary declaration pursuant to foreclosure loss MIT?
I'm sure we do.
And what are the circumstances in which your company would use your form as opposed to someone else's form?
If we were asked to generate the form, to provide them with a copy of a form. Yeah.
And when you say they, that would be the servicer who sent you the referral,
Yes.
correct? So is it safe to assume that the foreclosure loss mit form comes from the servicer generally?
Yes.
And other than the document, you have no way of knowing what basis they have to declare themselves to be beneficiary?
Repeat your question?
Other than the loss mit form that they sent you saying that they are the beneficiary. You don't call them up and ask them for the evidence
Object to the form.
of their status as
We do
beneficiary.
not call them and ask them.
Okay. I think this is when I want to take a lunch break. So, an hour. Okay?
Pause. The record reflected is now 11:44. We're going off the record.